Hi, Yolanda. How are you doing? Hi, Katie. How are you?
Doing all right.
Thanks for joining me.
Of course. We're just eating, so I'm gonna
What's for
mute.
what's for dinner?
Oh, we got takeout at Old Chicago since we can't go
Nice.
anywhere. We're in quarantine.
Nice. Old Chicago's good. Enjoy.
Thank you.
When I taught in Colorado, Old Chicago's was everywhere. It was a really big place. They had like a lot of pizza and really good food. And at the end of the term, we would have a party at Old Chicago's. Oh. How are you doing, Adrian?
I'm good. How are you guys?
Fine. It's already hit 90 out here in Nevada.
Oh, where are you?
I'm right outside of Las Vegas in
Oh,
Clark County,
that's why
Nevada.
you asked what my sister's name was, because I was like, well, how would she know her? She's not in, she's not there, but yeah, okay.
Yeah, it's already been 90 here. I'm looking forward to this summer. I'm ready for it to be 115. Last summer I went up to Lake Havasu. It's only 2 hours from here, and it was 122 degrees. Hmm. Climate change is fun. So welcome everyone to the Module 2 live session for the Legal Ethics course. This meeting is being recorded in case you would like to watch it again later. And our topic this week is confidentiality. Let's get started. Hi, Amara.
Hi there.
How are you doing?
Good, good. How are you?
Fine.
Great.
So, what is the duty of confidentiality, you might ask? The duty of confidentiality places restrictions on the disclosure of information related to the representation of a client or a potential client. The duty is described in ABA Model Rules of Professional Conduct, specifically Rule 1.6. And I posted a video in your course announcements explaining Rule 1.6, specifically the Illinois version of the rule. A lawyer should not represent information relating to the representation of a client unless the client gives informed consent. The disclosure would need to be impliedly authorized to carry out the representation, or the disclosure is permitted by an exception. These rules apply to potential clients and continue even after an attorney-client relationship is ended. So the relationship between the attorney and client is one that is very important in the American legal system. And it's so important that there is a presumption that anything that the client tells the attorney or anything that the attorney learns about the client will be held confidential. And this could even be something that you read on the internet, something you hear on the news, or you even read about in the newspaper. It's not just restricted to what the client tells you. It could be something you read about the client in a file. It could be something you overhear about the client. Any information that you obtain relating to the representation of that client, or if it's somebody who approaches you about a potential lawsuit, before the attorney-client relationship is actually established and formalized by a fee agreement. Even before that, the attorney has a duty to maintain the confidences of the client. So it's a broader duty than the attorney-client relationship, than the attorney-client privilege, and it continues even after the attorney-client relationship has ended. Let's talk about the paralegal's duty of confidentiality. Make this smaller. So, guideline 6 says a lawyer is responsible for taking reasonable measures to make sure that client confidences are preserved by the paralegal. Lawyers must act carefully, and they carefully need to train any employees, secretaries, legal assistants to ensure that client confidences are preserved. It's a matter of common knowledge that the normal operation of a law office exposes confidential professional information to non-lawyer employees in the office. So this obligates the lawyer to exercise care in selecting and training employees so that the sanctity of all confidences and secrets of clients can be preserved. So, with every rule, there are exceptions. Adrian, when do you think it would be permissible for an attorney to breach the duty of confidentiality and tell someone some personal information about the client? When do you think that'd be appropriate?
Well, when a client when a client gives that permission, or if they're going to be harmful to themselves or other people.
Okay, good. Yeah, there have been a lot of instances about the harmful to self or others. And this is in direct relationship also to the patient psychotherapist relationship as well. Ordinarily, a therapist is not allowed to discuss any confidential information relating to a patient. However, that patient, tells the therapist, "I'm getting ready to kill my ex-girlfriend." Um, and that's a situation where the authorities need to be notified. The same thing applies with the attorney-client confidentiality. If an attorney learns during a divorce, say, that a client intends to poison her husband, and this happens all the time. Do any of you watch any of these criminal reenactment shows like Forensic Files, Criminal Intent, American Greed? Type yes in the chat box if you've ever watched any of these criminal enactment TV shows. The thing about Forensic Files that makes it so good is it's all based on real cases. Okay, Amara says yes. Yeah, that's a great way to learn about criminal forensics and the legal system by watching Forensic Files and some of these other shows. Whenever it's a real criminal enactment of an actual case, and you can see how it's been solved, and you can see the many conflicts that attorneys and police officers and the difficulties and the ethical dilemmas that they face is really incredible. So here are the exceptions to the paralegal and the attorney's duty to maintain confidentiality. One, as Adrian said, to prevent reasonably certain death or substantial bodily harm. So it's a weighing system. It's where you weigh the pros and cons. Well, the attorney's duty of confidentiality to the client, that's very important for legal representation to exist. Because why would a client tell an attorney and a paralegal things if the paralegal could just go tell everybody else, right? The reason that you tell someone is that you believe that information will be held in confidence. And that's why attorneys and paralegals are held to a higher standard of moral conduct than the rest of the world. We can't just go around saying and doing anything we want, okay? We actually are held to a higher standard of ethics. And part of that is this duty of confidentiality, duty to maintain the client's confidences. We're not allowed to go to parties and gossip. about cases. Okay, that's unethical. So when are you allowed to disclose confidential client information? Well, the next one is to prevent a client's crime or fraud that is reasonably certain to substantially injure another property or finances. So this would be a paralegal learns that a client has hidden bank accounts during the course of a divorce. This might be a paralegal who's assisting corporate counsel and learns that the corporation that the board of directors had been cooking the books, had been hiding assets, had been self-dealing, and maybe the board of directors have been engaged in putting funds in their own private accounts, and that will injure shareholders' interest in the value of a corporation. Companies inflating their assets to attract more investors. If a paralegal learns about this, that should be reported to the appropriate authorities to prevent a fraud that is reasonably certain to injure another person's finances. To prevent, mitigate, or rectify substantial property injury to another. An example would be if an attorney learns that a company is defrauding its investors and decides to disclose the fraud to the investors in order to help them retrieve their investment. And if you watch American Greed, that TV show shows you how often this happens when companies are trying to defraud investors. It sadly happens every day. If an attorney becomes aware of that, there is a duty to disclose that information to the correct authorities. Any questions about when the duty to maintain confidentiality can be breached, or when there is an exception to that duty? Okay, here's another example. It would be okay to reveal confidential client information if an attorney needs to obtain ethics advice. This happened to me the first day I was working in a medical malpractice and insurance defense law firm. I was getting a case file was dropped on my desk. We were representing an insurance company, and our client was the insured party who had been involved in a car accident. And it turned out that he was trying to mislead the insurance company and the court into believing that he was driving the car. He was not driving the car. His friend was driving the car. Okay. And in many instances, insurance coverage depends on who's driving the car. Because if the insured person is driving the car, there's insurance coverage. But if a third party is driving the car, there may not be insurance coverage. So I had to get on the phone with the State Bar Ethics Hotline and get some information. So that was an exception to the attorney's duty to maintain confidential information, because I called the State Bar Ethics Hotline because I was concerned that a client was trying to perjure himself or defraud an insurance company or, misrepresent information to a court. So I decided to discuss that action with the State Bar Ethics Hotline. So that was an exception to my otherwise duty to maintain confidential information. Another one would be to establish a claim or a defense on behalf of a lawyer. So if a lawyer engages in negligent conduct during the representation of a client, the lawyer can be sued for legal malpractice. That's considered a tort or a civil wrong for which damages might be available. So if an attorney gets sued by a client for legal malpractice, the attorney may be able to disclose some confidential information to prepare their defense. Any questions? Another exception would be to identify and resolve conflicts of interest relating to a lawyer's change of employment, or a paralegal's change of employment. So, if a paralegal gets a job and starts to represent and assist an attorney in the representation of clients, the paralegal learns confidential client information. And because the attorney has a duty to avoid a conflict of interest, the paralegal has a duty to avoid a conflict of interest. So the paralegal cannot represent and take on a new client that would be adverse to an existing client. So if you're working in tort law, the paralegal is assisting an attorney with an injured passenger of a vehicle. You cannot then take on a case in which you'd be representing the driver of the vehicle. If the of the driver of the vehicle who causes an accident, you cannot represent both the plaintiff and the defendant in a lawsuit. That's a conflict of interest. And that conflict of interest exists when you continue on to a new law firm. So if you graduate from Rasmussen, you got your paralegal certificate, you get hired by a brand new law firm to work as a paralegal, they're going to want to know what cases you've worked on to avoid a conflict of interest. So in that instance, you may be able to reveal some confidential information. You would need to provide your new employer with the names and contact information for all work done at the previous firm to do a conflict of interest check. Any questions? So despite what you read in the media, legal professionals are not corrupt. We are actually held to a much higher standard of ethics than anyone else that I know of. Doctors are also held to a very high standard of ethics. Legal professionals are held to a high standard of ethics that's defined by all of these professional rules that you're reading every week in your assigned reading. Let's look at the National Federation of Paralegal Association Model Code of Ethics, Section 1.5. A paralegal shall not use confidential information to the disadvantage of the client or to the advantage of the paralegal or a third party. A paralegal may reveal confidential information only after a full disclosure in the client's written consent or where required by law or a court order, or where necessary to prevent the client from committing an act that would result in death or serious bodily injury. Again, you learn that the wife is planning on poisoning her husband, during the divorce case, and it happens. You would be able to disclose that information to the police, and you should. Paralegals shall not engage in any indiscreet communications concerning clients, which is why I recommend, and we talked about this some last week, is really being careful how you communicate in cyberspace. It would be advisable that a paralegal not discuss cases on Facebook, on LinkedIn, on Instagram, on any of those websites, because you don't want to risk violating Section 1.5. A paralegal shall not use this confidential information. No indiscreet communications, even with your friends, right? Your friends want to hear all about the cases you're working on. You're going to have to tell them, look, I'm not allowed to disclose any confidential information or I could get fired. Any questions, or are any of you currently working as legal assistants? Just type yes in the chat box if you're currently working as a legal assistant. Okay, Katie is. So Katie, have you come across any issues pertaining to confidential client information? Do you learn confidential client information? What do you do with confidential information?
I don't speak with clients. The information that I deal with are mostly sending out notices and more of the paperwork side of it. I work for a government agency that deals in like white collar crimes. Speaking of that, Bernie Madoff passed away today. So anyway,
Fascinating.
Anyway, so yeah, a lot of the stuff that I deal with is more of evidence and things like that. So I haven't had
Okay.
to come across that yet. So
Okay, in the documents that you're reviewing, there's often confidential client information there, because a lot of the information that legal professionals learn about clients is not through talking to them; it's in documents. Are you? I'm sure you sometimes need to view confidential documents.
yes, definitely.
And do you go home and tell your friends what you read?
No, no.
Exactly. So, that would be an indiscreet communication. So when you're as a paralegal, you're often reviewing confidential documents, government documents, evidentiary matters, and you're not allowed to discuss any of that information. So it sounds like you're being a good legal professional, Katie. Thank you for sharing that.
I try.
Let's take a look at some of these informal ethics and disciplinary opinions. So these opinions get generated when a paralegal has a question and decides to call the state regulatory authority about a particular issue. So the issue in this case is, what are the ethical implications concerning client confidentiality of paralegals communicating in cyberspace? Paralegals communicating in cyberspace through any form of electronic communication shall maintain and preserve client confidences and secrets. Electronic communications may include, but are not limited to, communications transmitted or posted through email, list servers, bulletin boards, World Wide Web, semi-public forums, websites, internet relay chats, direct messages, news groups, etc. Let's look at ethics opinion 06-02, which is part of your reading for this week. The issue in this is, what steps should a law firm take to preserve client confidentiality when the law firm hires or uses outside persons or businesses during its representation of a client? So what will often happen if a law firm takes on a big case and maybe there's only one attorney, one paralegal, and one legal secretary, then the law firm will need to hire some contracted lawyers, may need to get in touch with a temp agency, hire some document reviewers, and in that instance, the attorneys and their staff must abide by confidentialities at all times. When these contractors, outsiders are used by the firm, the law firm must take steps to assure that these third parties abide by the same confidentiality requirement, because again, the attorney is responsible for supervising their work. One way to accomplish this is to secure a contract commitment from the third parties, the temps, or the contractors, to preserve the confidentiality of all client-related information that they're reviewing in files. And it's a good idea, especially in the electronic age, in the age of cybercrime, cyber theft, to restrict the outsider's access to client-related information to only that which is essential to perform the specific tasks that the outsider has been hired to perform for the firm. Okay, so you do have a quiz this week, and let's review. So these are the things that I noticed. I took the quiz, and these are the things that I thought that it would be helpful to know and to study before you take the quiz. One is the scope of the duty of confidentiality. And note, it is broader than the attorney-client privilege, because the attorney-client privilege governs information the attorney learns, after accepting the representation of the client. The duty of confidentiality is much broader than that, and it goes to information the attorney learns about the client before, outside, and after the representation of the client. The duty of confidentiality covers not only information the client tells the attorney, but anything the paralegal may read in a confidential document, in the newspaper, gossip at a party, hears about on TV, any information a paralegal may learn about a client could be covered by that duty of confidentiality because it's very broad. The duty of confidentiality applies to electronic information, and it continues after the case is closed and even after the paralegal leaves the firm. We talked about the exceptions to the duty of confidentiality. Be sure to understand what they are and when they apply. So I would recommend take 30 minutes, study this information, and then take the quiz. Don't take the quiz first. Study first and then take the quiz. You'll get a much better result. So please be sure to submit the correct answers to the quiz by Sunday, April 18th. Let's take a look at your Module 2 written assignment. The purpose of the written assignment this week is to demonstrate how to protect the confidences of the client. So you were in the assignment, you are a paralegal in a small firm. Your supervising attorney is working on implementing new trainings and procedures for all employees and has asked you to prepare a PowerPoint presentation explaining what the duty of confidentiality means, who and what topics are covered by confidentiality, and the ways in which the firm can maintain confidentiality. So what you need to do is prepare 5 PowerPoint slides using proper spelling and grammar. And you can start by using this PowerPoint presentation as an example. So you just need 5 PowerPoint slides, 3 primary legal sources, rules, statutes, and cases, properly formatted using the Blue Book or the Indigo citation format. And be sure that you check that your presentation meets all the requirements that are set forth in the rubric. So let me go into the online classroom and let's take a look at the rubric. I want to share a web browser. Sharing a web browser. I want to be looking at Blackboard. There we go. So for every assignment, there is a grading rubric, and it shows you exactly where your points are coming from. So I want you to be able to view that rubric before you submit your assignment so that you can check off the requirements and make sure you're getting all the possible points. We're in Module 2. Written assignment, maintaining confidentiality. So I'm clicking on the Module 2 assignment, and there is the grading rubric off to the right-hand side. And I'm going to open that up so you can see where your points are coming from. All right. So you need to have 5 slides in order to get full credit. The content of the slides provide an advanced explanation of confidentiality and ways to protect client confidences. Slides are advanced in development, easy to follow, professional in appearance, no errors in spelling, grammar, and mechanics. And remember, Microsoft Word has a built-in editor, so just be sure to run the editor, do spell check, and Microsoft will highlight any grammatical or spelling errors and give you suggestions. And the last criteria for your references, use of 3 on-target primary legal sources. Any questions about the grading rubric?
Yes, I have one.
Yes, ma'am.
Oh, it just flew right out of my head. Oh, I know what it is.
That's
For the
right.
slides, do you want us to be like just like boring slides, or can we make them move around, or you know what I'm saying, right?
This is a wonderful assignment. You can get it creative as you want.
Okay, good.
Um,
And you don't want to
yes.
reference like an APA reference as one of the slides, right? You just want all Blue Book reference, correct?
Yes,
Or
all
written.
Blue Book
Okay.
references. Yeah,
Okay.
it's really not. I think that the syllabus may mention APA format. In-text citations are what you actually would need. So you would need to cite the rule on the slide. Within the context of the slide, you would need to Blue Book if you know whatever rule that you're citing to. Any other questions? So let's take a look again at our Blue Book resources. Under books and tools here on the left-hand side, view course and institution tools. It's opening up another window and I'm clicking on resources here off to the right. And there's tutoring. If you ever want assistance from a tutor, you would just need to click there. Off to this right-hand column, there are a number of resources. I'm going under paralegal. How do I cite using Blue Book guidelines? There is a sample Blue Book paper. That's how you would cite to a federal rule. Beneath this, here's a case citation, Blue Book format. So there's a ton of resources here that will help you if you have any questions about how to Blue Book your I just clicked on the Blue Book link. ABA model rules is what we are looking at and what you will be citing to, specifically Rule 1.6. There's how you do it right there. Model rules of professional conduct 1.6. Any questions about how you'll be preparing your Blue Book sites? You
Sorry,
don't see any. Yeah.
sorry, it's Adrienne again. So I started working on it today, and I had a question because one of my slides I wanted to cite only part of what my slide was representing of the 1.6 part, like comments and canon and all that stuff. So I got in touch with the library, and they had me cite it completely different than what's on here for like a partial, like it's a 2 sentences that I want to put in there. So I guess I'm going by what they say because I'm using the other citation too, the one that you just showed us that's on the screen, but then they said for a partial, it's a little bit different. So
It's like a comment or a note that you're citing to, a comment or a note.
yeah, but they didn't even, it was weird the way they said it, but I was like, oh, okay. And she said, this is correct. I'm like, okay, I'm going to do this. So I'm just telling you ahead of time. The library told me how to do this.
That's fine. I'm not going to get real nitpicky and I'm not splitting hairs about citations. as long as your citation appears reasonable, it appears neat, and the reader can ascertain what you're citing to, I'm not here to make your life hard. So if you've contacted the library and they've given you some cite format, that's fine with me, as long as it looks reasonable. It's funny because I recently bought a copy of the Blue Book. It's always good to have this on hand. But yeah, fortunately, you all, are able to get all this information in cyberspace, so you don't have to worry about this. So yeah, as long as your citation is reasonable, that's fine with me. Any other questions? Great, let's go back to our PowerPoint slide. We are almost at the end of this live session. Great, so everyone understands what we need to do here for this. Prepare 5 PowerPoint slides describing how to protect the confidences of a client. And I would expect that your PowerPoint slide would include some reference, as Adrian pointed out, to Model Rules of Professional Conduct 1.6. Guideline 6, the lawyer is responsible for taking reasonable measures to ensure that all client confidences are preserved by a paralegal. The lawyer must carefully select and train employees. So these would also be rules you could cite to. Guideline 6, Model Code EC 4-2. National Federation of Paralegals Association Model Code of Ethics, Section 1.5. That is a primary source you could rely on, etc. Again, if you have any questions, reach out to the writing lab, make an appointment with a paralegal tutor. This explains how to do that. When I send out this PowerPoint slide, all of these links are active in the slide. So if you need help, you'll be able to click there directly to reach a tutor. You'll be able to click here for a list of FAQ answers, for how you access writing support, and you'll be able to click there for any resources on the paralegal pages, because those will all be active links in the slide presentation. Okay, so for Module 2, no live session question. I just need you to submit your Module 2 written assignment and complete the quiz by Sunday, April 18th. Any questions? Thank you so much, Adrian, Amara, Katie, and Yolanda, for your excellent participation in the Module 2 live session. I hope you have a terrific week, and I will see everyone in cyberspace.
Thank you.
Thank you.